Let's bring back criminal defense attorney, former head prosecutor Bob Bianchi to discuss. Listen, I thought the best part of the testimony for the state was when there was testimony that Fatima said he tried to kill me, referencing her father, and then saying, and the mother came around and choked me too. But then when you hear on cross, but they didn't call law enforcement, Bob. I think that's a point for the defense.
Yeah, I mean, I don't know the laws of that state, but in most states, I know certainly in New Jersey, you have an affirmative obligation to report immediately to law enforcement. So if that is the same kind of rule or procedure there, you can be assured the defense is going to bring it out. But I will say this, I got to give the prosecutor props. I love the way this prosecutor asks questions, tight, to the point, and she does a thing called looping, where she's using these great words like staggered. I started counting at 3. I think it may have been like 6 times she used that word, staggered in the room, and choked so many times that she mentioned that. With each question, she was placing that word in there, drawing a very vivid picture. She did a really tremendous job, and I think it was effective. But, Judge, to your point, in the end of the day, why didn't they do something like that if it was so bad?
Yeah,
I agree. Let's check out on a comment from one of our viewers on our YouTube feed. This is Karen Hall. She says, I still think without the honor-killing aspect, the prosecution has an uphill battle. And on some level, I definitely agree with that. But I think the way that this, actually the examination, the direct examination, and even the cross went of this particular witness, I thought they went a long way towards getting over that hump. Bob?
Yeah, I don't know. I don't disagree with the viewer that's putting that in there. And I do believe that that started to drive the scenario in this case. But these are just words. These are concepts. It doesn't necessarily mean that that was what the intention was. Again, keeping in mind that some of these crimes require a purposeful mental state, which means that that was their actual intention to commit that crime. Not that they said certain words. I mean, words can be used, but not in this particular instance. So it's hard for me to say. In the end, I'm going to come down to the same thing. If the people believe culturally there's some differences there and that these parents did not want to purposefully harm this child and that they were looking out, the judge's question before, to the safety, health, and welfare of their child, they're going to give some liberality to maybe even some excessive force in this particular situation. In my humble opinion, as a prosecutor, I'm worried about that one juror that may feel that way.
Well, let me ask you about the specific charges as to the father, Bob. And the charges are on the first count, second-degree attempted murder, only carries up to 15 years. But the second count, first-degree assault, carries up to life. And I think the first-degree assault is, at this point, for me, clear in terms of the evidence presented.
Yeah, Judge, I always tell people, this is a truism. The attempted murder charges, to me, have been the most difficult to prove as a prosecutor of any charge I've ever had. And that's because the attempt requires itself to have a purpose, which means you have to infer it from the state of mind and circumstances of an individual. But to your point, the evidence is much more direct here and the charge is much higher. So that's where prosecutors want to go, that this was something that could have caused, or that there was an intention to cause, serious bodily injury. And that's why this testimony about how easy it is to, to choke somebody out and things of that nature is being introduced here. But again, they're going to have to really go to a high burden here that that's what the parents were really trying to do, really trying to harm their child. They may have harmed their child, but in the end, the defense is like, but they didn't, in the end, really harm their child. It's a really nuanced case.
And it's a tough sell for a jury to believe that two parents who, I guess you would think, they obviously love their children, would be out to kill their child unless you have this cultural aspect. I think that's what Karen Hall was speaking to. And I feel like with the way the evidence is in this case, Bob, if the husband, for instance, the father, takes the stand and simply looks at this jury, I don't know if he's capable of this, but looks at this jury and in a sympathetic way say, look, there was no way I was trying to kill my own child. The situation escalated. It was escalated by all these things going on around me, and I never would kill my own child. I think that's more than enough.
Well, that's a really great thought, Michael, because essentially what you're saying is, would you as a defense lawyer ask your client, based upon the strength of the evidence that's been produced by the state, to get on the witness stand and testify? Because we know that is filled with peril as well, and gives the prosecutor, it may not even be on the substance. It may be just the way the person is, their personality, how they answer questions. I'd have to really go over with my client whether or not I think enough evidence has been presented right now to even convict him, because there could be all these sympathy factors that we're talking about here right now. That is going to be a huge question. In the end, as a lawyer, we give our advice, but the client's going to make make the call there. But we also know sometimes, I've always said this to you guys, we love the prosecutors say we love to convict out of the mouth of the defendant. That's what's most persuasive to a jury. So it is wrought with peril for him to get up there.
And then you wonder, Michael, if he would open the door to things like honor killing and that being admissible. You and I talked about that.
Yeah, I'm not sure about the judge's ruling if it was absolute or, in fact, could he open the door?
Yeah, it's a risk.
Yeah.
Well, maybe. We just don't know for sure. All right. Thank you, Bob Bianchi, as always, for joining us.